Welcome to the deep dive. We're cutting through the noise today, getting straight to the core of, well, a pretty complex topic. We're taking a close look at two recent, and I think really significant, decisions from the Delhi High Court in India. We're really digging into the world of patent appeals. Now, we've got quite the stack of sources here for you: articles, summaries, legal docs, even bits from the court orders. And they all revolve around appeals filed by two major players, Fresenius Medical Care and Blackberry. This was after the Indian Patent Office refused their patent applications. So our mission today, it's pretty straightforward but crucial. We want to unpack exactly what happened in these cases, understand why they ended up in court, get into the specifics of what the High Court decided, and maybe most importantly, figure out what these rulings actually mean for patent law and practice in India. We'll be focusing quite a bit on the rules around, changing or amending your patent claims during the whole process and how the Patent Office is supposed to handle things.
Right. And you should think of this as like a look under the hood of the patent system's engine room. We're seeing how disputes over inventions get handled, how they get resolved when they actually escalate up to the courts. These cases, they aren't just isolated incidents, They really highlight some crucial procedural issues, substantive issues too, that applicants in the Patent Office grapple with pretty regularly. They offer some genuine insights, I think, into how the system adapts as technology and, well, legal principles evolve.
Okay, let's dive into that first case then. This one involves Fresenius Medical Care Deutschland. They were appealing a decision against their patent application.
That's right. Their application number, for those tracking, was 7493DELNP 2012. It came from a PCT filing. This was the national phase entry in India. The invention itself was quite specific. It was about microvesicles, MVs, derived from adult stem cells for use in the therapeutic treatment of a tumor disease. So pretty cutting-edge stuff.
Right, using components from stem cells to potentially treat cancer. That sounds complex. What kind of hurdles did they hit at the Patent Office? What went wrong initially?
Well, the controller refused the application back in 2020, and the objections were quite numerous. They cited a lack of novelty for some claims, a lack of inventive step for the whole thing, issues with sufficiency of disclosure, clarity. And importantly, they also hit it with Section 3E. That's for things considered just a mere admixture, and Section 3I, which relates to methods of treatment, both generally not patentable subject matter in India.
Wow, okay. So novelty, inventiveness, disclosure issues, and the Section 3 exclusions, that's a lot to overcome. So Fresenius obviously decided to fight it.
Oh, absolutely. They appealed. Initially, it went to the IPD, the Intellectual Property Appellate Board, but then, the IP was dissolved, so their case, like a lot of others, got transferred over to the Delhi High Court. And a really critical part of their strategy during this whole appeal process was proposing amendments to their claims, trying to fix the problems.
Okay, tell us about those amendments. What were they actually trying to change or maybe clarify in their application?
Yeah, this is where it gets really interesting, sort of from a legal process standpoint. Over the course of the prosecution and the appeal, they actually offered several sets of amendments. It wasn't just one shot. Initially, they tried changing the main independent claim. Instead of just the microvesicle for use in treatment, they changed it to a pharmaceutical composition that contained the MV plus cytotoxic or cytostatic agents. And later, they even added dosage information, something like zero point 0.1 to 200 micrograms per kilogram body weight. Specific details.
Okay, so they're refining it. What did they finally put forward to the High Court during the actual appeal hearing?
Right. So before the court, they presented what they called Auxiliary Set 2. This refined Claim 1 even further. They made it more explicit, stating that the microvesicle inhibits tumor cell proliferation and Engador induces cancer cell apoptosis. Getting into the mechanism. And they also specified those cytotoxic or cytostatic agents, narrowing them down to doxorubicin or vincristine specifically, but they kept that dosage range they'd added earlier.
So, adding more detail on how it works and what it works with, what was their argument? Why should the court accept these changes so late in the game?
Their core argument was basically, look, this isn't new stuff we're sneaking in. They argued these amendments were just explanation and disclaimer, clarifying and narrowing what was already disclosed in the original patent documents they filed way back. Critically, they argued it wasn't adding anything new or broadening the scope of the invention. And they also pointed out, hey, this invention has already been patented in places like China, Europe, Japan, the US. Other major offices thought it was okay.
That comparison is always interesting. So how did the High Court see it? Did they buy that argument about explanation and disclaimer?
They did. Crucially, the court allowed the amendments. This was a really significant move because allowing amendments at the appeal stage isn't automatic.
Right. Why did the court find these amendments acceptable? What was the legal reasoning there?
The court really zeroed in on Section 59 of the Patents Act. That's the key section governing claim amendments. They found that Fresenius's proposed changes fit the bill under Section 59. Specifically, they agreed they were in the nature of explanation and disclaimer, clarifying, narrowing. The court concluded the amendments did not broaden the original scope, and crucially, that the subject matter being added or clarified was actually already disclosed, already supported in the original patent specification. It wasn't coming out of nowhere.
Okay, so Section 59 is the gatekeeper. You can explain, you can disclaim, narrow things down, but you can't add completely new concepts or try to cover more ground than you started with.
Exactly, that's the essence of it. And the court made a point of saying that the High Court, has the power similar to the controller under Section 15 to allow these kinds of amendments during an appeal, provided they strictly meet those Section 59 requirements. They even cited some precedents, Société des Produits Nestlé SA and OpenTV Inc., to back up this power.
All right, so the amendments are in. What did that mean for the final outcome of the Fresenius appeal itself?
Well, because the court allowed those key amendments, they then set aside the controller's original refusal order. The initial rejection was quashed, but the case wasn't completely finished, It was sent back or remanded to the patent office.
Remanded for what, just a rubber stamp? Or a whole new look?
Essentially, yes, for a fresh examination. But, and this is key, specifically based on the amended claims that the High Court had just given the green light to. The court was quite specific, even directing the Patent Office to make a decision on this re-examination within 3 months. Put a clock on it.
That's very direct. But did the court, by allowing the amendments, kind of signal that the amended invention was now definitely patentable? Did they weigh in on the merits?
That's a really important distinction. And the court was very careful about this. They explicitly stated that by allowing the amendments and sending it back, they were making no observations whatsoever on the actual patentability merits of those amended claims. That decision, whether the invention as amended now meets all the other tests, like novelty, inventive step, Section 3 stuff, that job is solely for the controller to do during the French examination following the law. The court's role in the appeal up to that point was focused mainly on whether the amendments themselves were legally okay under Section 59 and whether the original refusal was sound given those amendments were possible.
Got it. So they fixed a procedural hurdle, clarified the amendment rules for this case, but the ultimate question of patentability goes back to the Patent Office.
Precisely. They corrected the course, essentially.
Okay, that wraps up the Fresenius story, for now at least. Let's shift gears then to the second case we look at, the Blackberry appeal. How did this one end up before the High Court?
Right, so this appeal was filed by Blackberry Limited. They were challenging a refusal order from the assistant controller that came down in 2019. This was also an appeal under Section 117A of the Act. That's the standard route for appealing Patent Office decisions to the High Court. Their application was 1071 Taindel 2007, an older one.
And what was the invention Blackberry was trying to patent here?
This one was titled Method and System for Signaling Release Cause Indication in a MTS Network. MTS, that's Universal Mobile Telecommunications System, basically 3G mobile tech. So this was about radio resource control in mobile networks, specifically how a signaling connection is properly released or ended within that kind of network, very much in the software and telecom space.
Okay, another complex technical area. What reasons did the Patent Office give for refusing this application? Similar issues to Fresenius.
Well, yes and no. Like Fresenius, the objections raised in the first examination report and the hearing notice were pretty numerous. They included lack of novelty and inventive step under Section 21J. There were also non-patentability objections under Section 3K. That's the one covering mathematical methods, algorithms, computer programs per se, and also Section 3 meters for mere schemes or rules. Plus, objections about clarity, unity of invention, and also an issue under Section 8, which deals with providing information about corresponding foreign applications. So a whole range.
And did Blackberry also try to amend its claims to get around some of these?
Yes, they did. They filed amended claims along with their submissions after the hearing, and their argument was, in principle, similar to Fresenius. These amendments fall within Section 59. They're just corrections or explanations, and they're fully backed up by what we originally filed.
Okay, so they tried the amendment route, too. How did the controller react to Blackberry's proposed amendments?
And this is where the absolute critical issue in the Blackberry case really comes to the forefront. The controller, in the final refusal order, flat out rejected these proposed amendments. Okay, fine. But the order simply stated that the amendments didn't comply with Sections 57 and 59. Full stop.
Yeah.
Crucially, the controller provided zero reasoning for this conclusion. None whatsoever.
Wait, hang on. So the Patent Office order just said the amendments don't comply with the rules without explaining why they don't comply.
Exactly that. Just a bold statement. The order was incredibly sparse on this crucial point. It even, apparently incorrectly, stated that BlackBerry's agent was silent on the amendment objection, when the court documents suggest they did file arguments supporting the amendments. The High Court itself, in its judgment, used the word cryptic to describe the controller's rejection of the amendments.
Wow. That sounds, well, like a major procedural problem. So what was BlackBerry's main argument when they appealed to the High Court? I imagine they focused on this.
You bet they did. Their key argument, and the one the court really latched onto, was precisely this lack of reasoning. BlackBerry argued, look, the controller has to provide a reasoned decision, what lawyers often call a speaking order. It needs to explain why, step by step, the proposed amendments fail to meet the Section 5759 requirements. They argued, how can we understand the rejection, let alone challenge it properly on appeal, if we don't know the basis for it?
Makes sense. And what did the High Court decide? Did they agree with BlackBerry on that?
Unequivocally, yes. The court agreed completely with BlackBerry on this point, and based primarily on this fundamental flaw, they set aside the entire refusal order.
So the whole thing was overturned just because the controller didn't explain the why behind rejecting the amendments.
That was the core reason, yes. The court really hammered home the point that a reasoned decision is absolutely essential when rejecting proposed amendments. It's not optional. They cited a precedent, Agriboard International LLC, and stressed that this principle aligns with basic natural justice. Fundamental fairness requires you to be told the reasons for a decision against you. They even brought in a Supreme Court case, Manohar, just to underscore the general importance of reasoned administrative orders across the board.
That's a really strong statement about procedural fairness from the court.
Right.
So, like the Fresenius case, was this one also sent back, remanded to the Patent Office?
Yes, it was also remanded, but the instruction was for a de novo consideration. That means they have to look at it completely fresh, basically start the examination over regarding the objections. And the court gave very specific instructions about the order of things this time.
Oh, what were those instructions?
The court told the controller, first, you need to properly examine those proposed amendments under Sections 57 and 59. And critically, you must provide a full reasoned decision explaining whether they're allowed or why not. Then, and only then, based on whatever you decide about the amendments, you need to address all the other objections. Novelty, inventive steps, Section 3, Section 8, all of that. And they also explicitly directed that BlackBerry be given a fresh hearing. A complete do-over, but with clear steps.
Oh, it really sounds like both cases highlight how important that amendment process is, but BlackBerry has this really strong emphasis on the process itself. The Patent Office absolutely has to explain itself clearly.
Exactly. That's a great way to put it. While Fresenius shows the High Court can and will step in, assess amendments itself under Section 59, and allow them if they comply, BlackBerry serves as this powerful reminder, maybe even a warning to the Patent Office, about its fundamental duty to follow proper procedure and provide clear, reasoned justifications, especially when rejecting amendments. And the court in BlackBerry also, sort of in passing, reiterated that general principle, citing cases like Nippon A&L Inc., and AbbVie Biotherapeutics Inc., that amendments are allowed if they stay within the original disclosure scope. It reinforced the underlying rule, too.
Okay, so let's try and bring these two deep dives together. What's the big picture takeaway here for you, the listener? Whether you're an inventor, maybe a company filing patents in India, or just curious about how ideas get protected.
Well, these rulings, and it's interesting, they were decided just a week apart by the same judge. They offer some really critical guidance, I think. First, they definitely reinforce the High Court's active role in its power in patent appeals, including, importantly, its ability to evaluate proposed claim amendments itself and allow them if they meet that Section 59 criteria. Basically, amendments are okay if they're genuine explanations or disclaimers backed by the original description, and crucially, don't broaden the scope.
And the BlackBerry case adds that vital procedural layer, right?
It absolutely does. BlackBerry is just this really clear, unambiguous message to the Patent Office, saying no isn't enough. You have to provide reasoned decisions. Particularly when you're rejecting amendments that an applicant thinks might fix the problems, they have to explain why. And this isn't just about, bureaucratic box ticking. It's fundamental to ensuring transparency. It allows applicants to understand, maybe address the issues, and it makes the whole administrative process accountable and properly reviewable by the courts later if needed.
So for someone navigating the system, these cases seem to show that, okay, amending claims is complex, but it's definitely a possible path forward during prosecution or appeal. And maybe more importantly, the Patent Office is being held to a standard by the courts. They must process these things properly and clearly communicate their decisions.
Yeah, I think they really clarify that interplay between sections 57 and 59 on amendments, and they strongly link it to that fundamental administrative law principle. You need reasoned decisions. It kind of provides a clearer roadmap, both for applicants who are trying to get appropriate amendments accepted and for the Patent Office and how it absolutely must evaluate them and explain its findings.
That was genuinely fascinating, a real look into the nuts and bolts of patent appeals in India. It really highlights how things that might seem like small details, the exact wording of an amendment, or just the absence of a clear explanation in an official order can have huge consequences in this pretty complex world of IP law.
Indeed, it does. It really leaves you thinking, doesn't it, about how procedural fairness, clear communication from these administrative bodies, it's just as vital, perhaps, as the technical brilliance of the invention itself when it comes to actually getting innovation protected.
Hmm. So here's a final thought maybe for you, the listener, to mull over. How does this requirement for reasoned decisions, which we've seen is so critical in patent law here, how does that apply in other areas?
Hmm.
Where government agencies or administrative bodies make decisions that really impact people or companies? Does demanding that why behind the what always lead to better, fairer outcomes overall? Something to think about. Well, thanks for bringing this hefty stack of sources to us for this deep dive. It was quite a journey through those cases.
It was complex, definitely, but yeah, a rewarding exploration. Glad we could unpack it.
Join us next time for another deep dive into a topic brought to us by you.